Committee, please tell us your full name.
It's Christian Severe.
What's your last name?
It's Severe.
Very good. Welcome. I have to ask you to raise your right hand. Do you swear affirm the testimony you're about to give the committee will be the truth, the whole truth, and nothing but the truth?
Yes, Mr. Chairman.
Our bell is ringing, so I'm going to say go, but we're going to have to recess this meeting shortly. Senator from Jefferson.
Okay, Christian. Obviously, there's been some questions raised about the constitutionality. I mean, there were several things, and we have limited time. Could you tell us about the obscenity definition?
Sure, yeah. I took notes for all questions. I think I've got answers to every single question that was raised, by the way. So in terms of obscenity, I've talked to Apple as well. I talked to them in federal district court.
You may want to pull that microphone a little closer.
A little closer, okay.
There you go. That's
so I talked to Apple as well in federal district court. After working with FBI and Special Forces to do extractions overseas, we sued Apple for having their products being sold in a condition that's dangerous and defective. So when I talked to Apple, I talked to Professor Ford, who is like talking to Tim Cook himself. One of the defenses they raised is we don't know what obscenity is. One man's lyrics, another man's vulgarity, which we said, Your Honor, that's intellectually dishonest. The code clearly defines what obscenity is. We have, as the senator mentioned, that we have the I know it when I see it standard given us to by the Supreme Court. We have the Miller standard. We have the code here clearly defines it as well. And so, you know, I like Justice Scalia's position that vulgarity is vulgarity. So it's pretty clear what is obscenity. And we always would tell the judge, you know, ignorance of the law is no excuse. So anyone who tries to say we don't know how to define obscenity is just trying to facilitate the continued distribution of pornographic materials to minors for some kind of self-interested greed issue. So if that answers your question.
Okay, well, that's a beginning.
Yes,
what about the constitutionality of?
So the only language I speak is in the language of the Constitution. So we've got materials here where we have controlling Supreme Court authority. And number one, we have the Supreme Court decision in Ginsburg. Ginsburg was the case that said that the display statute, which West Virginia has and all 50 states have, which is a statute that says if you're a retailer and you sell your gas station or a newsstand, and you sell Playboys and Hustlers, you can do that. You can sell them next to a hunting and fishing magazine. Playboy and Hustler have to go behind a blinder rack that can only be installed by the retailer or manufacturer, that can only be removed. The consumer's over 18 and shows proof of ID. If they do that and they pay for the content, the retailer is required to then remove the filter, and the adult consumer can have access to that. The magazine, the girly magazines is what they call them, with a few naked pictures. Now, those magazines don't have child pornography, prostitution hubs, or volumes of obscene content, but those statutes have survived First Amendment heightened scrutiny. So the controlling Supreme Court authority here is Ginsburg, because since it's been upheld under First Amendment heightened scrutiny, that a physical filter statute that requires physical bricks and mortar stores to put physical pornography behind a physical blinder rack is constitutional, then a digital display statute, which this bill is, that requires digital retailers to put prostitution hubs, child pornography, and obscenity behind a digital blinder rack, that too is constitutional as the least restrictive means.
So essentially you're saying we're treating those retailers the same as the retailers who sell Playboy in their stores.
Yes, ma'am, except, I always loved raising this question in federal court to Google, Microsoft, HP, Dell, Verizon, and so forth. We'd say, why is it, Your Honor, that a 12-year-old in the state of West Virginia cannot go buy a girly magazine? They can't even go see an R-rated movie, but they can walk around with an X-rated theater in the form of a filterless iPhone made by AT&T and sold by the local Verizon store. That's a double standard, is it not? And isn't it a crime right now for retailers to distribute pornography to minors? And isn't it a crime right now for retailers to promote prostitution? I mean, there's no doubt that by just blocking prostitution hubs alone, which is easy for them to do, they already have the technology. All the schools have filter technologies right now. This building has filters as well, but those are third-party filterings, and they don't have the insider knowledge. There's no burden on them to maintain the quality of the filters. And the real reason why the bill is constitutional is because this bill has nothing to do about adults and their desire to access pornographic material or prostitution hubs and so forth, a lot of which leads to hardcore victimization and criminalized activity. This bill is about protecting children, but the reason why it's constitutional is because the Internet is going to be just like it is in all of its glory. This is a perfect use of the state legislature. There are 39 states moving on it, and I know that no one wants to be first, but I'm very confident we're going to have a huge number of states pile on and do this. We have federal sponsors. We have a list here of hundreds of people who are signed on, Democrat and Republican, because this is a common sense, we're going to opt people in scenario. It's going to do more to fight human trafficking than any other measure since the inception of the Internet. Sorry.
No, that reminds me of another another point that was brought up, that we might be putting obstacles to adults
Right.
to being able to, basically have their freedom.
Right. So basically, right now, if someone wants to build a strip club here in the capital city, they can do that. But the legislature can zone those strip clubs, the adult establishments, which already have secondary harmful effects. The Supreme Court has found relentlessly that the states have a compelling interest to uphold community standards of decency, and that those kind of establishment obscenity has secondary harmful effects. It's not even speech; it's stimuli. But anyway, so they can zone those strip clubs to the hard-to-reach parts of town. And what that zoning ordinance is, it's a barrier, it's a filter. It makes it more inconvenient to access the content. So, just as the zoning ordinances make it more inconvenient, this digital display statute just makes it more inconvenient to access this criminalized content, which is harmful, unprotected speech. I mean, countless states are passing resolutions right now that declare pornography as a public health crisis.
Excuse me, I'm loath to interrupt you. This is all fascinating, but I will now recognize the senator from Brooke. I guess recess as opposed to adjourn. Senator from Brooke.
Thank you, Mr. Chairman. I move that the committee stands in recess.